Are you going to
Nevada.
talk
She's
over me,
moved out
sir?
of the
Sir,
jurisdiction
this
of
is the
Nevada. I
judge.
don't know.
Sir, please stop talking. This is the judge. You're represented by counsel. All right?
My counsel in Oregon is not present, so that's why I'm speaking
All
on
right. Well,
that.
I would just note for the record that Mr. McDonald is improperly in the chat making his arguments. I don't know if that's part of it.
I asked my office to text him not to do that.
So I just wanted to make sure that we had everybody before we proceed. And Judge Gordon, I believe you're on the line.
Yes. Good afternoon, Judge.
Okay. Good afternoon, and thank you for being available. I'm the one who asked for this hearing. So I'm going to go ahead and call the case, and we'll talk together about how to proceed. And I think just a moment. Do you have the name of that attorney that's on for? Okay. All right. Well, my name's Judge Easterday. We're here in the Jamhill County Circuit Court. That's in McMinnville, Oregon. The case. This is in the matter of Candace McDonald, now known as Candace Ruiz, and Michael McDonald. We had his attorney of record as a John Cochran, but I understand there's another attorney appearing on behalf of Mr. McDonald. Will you please give me your name
Yes,
and
Your
bar
Honor.
number
This
again?
is attorney Val Fuji, bar number 5955. I'm court-appointed counsel in the Clark County matter.
Okay, very good. And on the video, we do have Ms. Ruiz, Mr. McDonald, the attorney. We have, and I was trying to get the official name, Mr. Gordon, Honorable Gordon, District Court Judge at 8th Judicial District Court Family Division. Did I get that right,
That is
Judge?
correct. That is correct.
Okay. And here in Oregon, we did have that Clark County, Nevada case D-15-518-905-D judgment entered as a foreign judgment just recently. Mr. McDonald has also filed in Oregon a motion to modify that Nevada parenting plan. And given that, it seemed the next step would be for me to have a UCCJEA, which of course stands for the Uniform Child Custody Jurisdiction Enforcement Act. The statute allows a court may communicate with a court in another state concerning a proceeding arising under this act. The court may allow the parties to participate in the communication. A record must be made of the communication, and so parties were informed, and that's what we're doing today. Judge, is there anything that I missed before we continue?
No, let me just call my case over here. It's D23661-332-R in the matter of the parental rights of. And then I just want to note Mr. Fleeman's appearance. Mr. Fleeman, will you make your appearance, please?
Yes, Your Honor. Jack Fleeman, bar number 10584, on behalf of my client, who's also present as noted.
All right.
And who's your client?
Ms. Ruiz in Nevada.
Ms. Ruiz, thank you. Okay. Okay, well, thank you. So, and I always feel a little clunky on these hearings. I do them so infrequently. But I was looking at our statute. I was looking at the jurisdiction to modify and the procedure for that. But I guess more importantly, I thought that because my understanding, judges, is there's simultaneous proceeding. There's actually an active proceeding regarding the custody of the children in Nevada at this time that may kind of stall things. The statute says a court of this state, which is Oregon, may not exercise its jurisdiction if at the time of the commencement of the proceeding concerning the custody of the child has been commenced in a court of another jurisdiction.
Well, the proceeding.
So
the proceeding that's pending in Nevada
Okay.
is not a proceeding for custody. The custody action, the D15 case that you referenced, that you have registered the foreign judgment, that case is currently inactive and closed in Nevada. The case that is active in Nevada is a petition to terminate Mr. McDonald's parental rights. That's the D236613332 case, and that is pending. So we essentially have two separate proceedings that are pending at the same time and potentially in conflict. One is the motion to modify custody that's pending there in Oregon, and then the termination proceeding that's pending here in Nevada. I think there are a couple of issues that the courts need to discuss and agree upon or address, and that is, one is the residence of the parties could be an important consideration. There's no dispute that mom and the minor children are residing in Oregon and have been residing in Oregon for I believe at least 3 years, the last 3 years. There potentially is a dispute as to where Mr. McDonald is residing. He contends that he's now residing in Arizona. That's the representations he's made to the court, the position he's taken in Nevada. I'm not sure what he's alleging there in Oregon. I'm assuming he's alleging in Oregon that he's a resident of Arizona. Mom may dispute that point. That may be a fact question. It may have some bearing in the sense that if in fact Dad has left the state of Nevada and is residing in Arizona, then in fact at the time that the judgment was registered in Oregon and the motion was filed there, all parties had left the state of Nevada when that petition was commenced, and if Dad is in fact residing in Arizona, then Nevada would not have jurisdiction over that custody proceeding, the one that's pending in front of you. And then what the court would grapple with, or what the court is grappling with here in Nevada, is whether it wants to proceed with the petition on the termination of parental rights, or whether it feels it's in inconvenient form, given that there's an action pending for custody there in Oregon. The parties have all left the state of Nevada, and the custody action here is inactive and closed. So I think the first issue we need to address is the issue of Dad's residence, and then we can discuss the issue of inconvenient form.
Okay. All right. I'll turn to, I'm not sure if the parties are prepared to put on evidence. I'll turn to Ms. Fuji.
Thank you, Your Honor. I may be able to add some clarity, and I know Mr. Fleeman can do this as well. The issue, just procedurally, my client successfully completed his parole and was honorably discharged on or about February 3rd of 2023. After that, he did a brief focus psychological assessment, April 3rd, 2023. He filed an affidavit in support of a registration of an out-of-state child custody determination in Jamhill County on March 31st, 2023 in 23 DR 05784. He also attempted to file a motion to modify custody in the same case, but procedurally it was ineffective. Ms. Ruiz moved to terminate his parental rights in Nevada and filed that on April 4th. The parties first met with Judge Easterday at a UCCJEA conference. The court minutes from that were done on May 5th, 2023. Both Mr. Fleeman and I were there. We were instructed by Judge Moss in anticipation to file briefs on the UCCJEA issue. Both counsel filed briefs that will address a lot of these issues, I think, before this court. So if that would be relevant, I'd be more than willing to share that and provide that to Judge Easterday. The court at that time, Judge Moss said discovery was open on the issue of my client's residency. He had filed proof of a change of address in White Hills, Arizona on April 24, 2023, and through the commencement of discovery provided proof of a utility bill, driver's license showing residency in Arizona. Then counsel for Ms. Ruiz did a motion for summary judgment on this UCCJEA issue, which came before the court, and that was denied without prejudice. And that was just procedurally the background I wanted to offer.
And this is Attorney Jack Fleeman in Nevada. If I may, I just want to correct part of the record that was made there in that while her client did file to register the custody action in Oregon sometime around, mid-year, spring of last year, our petition to terminate was actually filed last January, more than a year ago. It was not filed in April. It was several months later that Mr. McDonald filed the first attempt to register in Oregon. It's now over a year later. We have a trial set in the petition to terminate for June. My preference is to be able to file maybe simultaneous briefs on the issue of residency and inconvenient form.
I would not be opposed to that, counsel. I think if everybody, the more information, the better. Our request, of course, is that Nevada stay to proceeding under NRS 125A 3653 and allow, and you know, I know we both have different positions. We would like, my client would like, as it is a non-convenient forum in Nevada, and that there's a simultaneous proceeding to argue those facts. We can brief and then argue those later.
My preference would be a simultaneous brief and then maybe a short evidentiary so the courts can actually take some testimony from the parties, if possible.
I would not oppose.
Mr. Fleeman, the standard for
the
standard for residence is presence. What's the offer of proof as far as what your client can show to dispute Mr. McDonald's assertion that he's not physically present in the state of Nevada, that he resides in Arizona?
The offer of proof is that he is physically present in the state of Nevada, we believe every single day, but definitely the majority of time. And he does spend overnights in the state of Nevada as well. We do believe he's also working in the state of Nevada now, as in addition to that.
And so the evidence that would be proffered at the evidentiary hearing would consist of what?
It would consist of an investigation that's been done that shows where he has been located, where his car has been located, where he has gone during the days. We also have his social media previous to the last hearing, where he was posting where he was in Las Vegas pretty much every day, although he seems to have shut down the social media side.
Okay. And then even regardless of his residence, either court is in a position to be able to decline jurisdiction, correct?
I believe that Nevada's in the position to relinquish or decline to exercise in favor of Oregon. I don't think it could be the other way around, based on the statute that the Oregon judge quoted, which is the same in Nevada, that states that once there's a proceeding that's commenced, it can't go forward until the other state, I believe, recognizes itself as an inconvenient forum.
You would agree with me, though, that the proceeding that's been commenced in Nevada is a petition to terminate parental rights. It's not the custody proceeding. The custody proceeding in Nevada has been closed for quite some time. And so if, in fact, Mr. McDonald left the state of Nevada, correct, then Nevada lost jurisdiction over any potential new filing, such as his newly filed motion to modify custody.
I don't necessarily agree with that. I agree in part that the termination of parental rights isn't a custody proceeding under the custody statutes. However, under the UCCJEA, it is defined as a custody proceeding.
Correct.
It's
a proceeding in and of itself, but it's not a proceeding to modify custody. It's a proceeding to either terminate parental rights or don't terminate parental rights. So if there's
substantively,
right, if your client, if the court finds that he left the state of Nevada, right, then it lost jurisdiction. And if your client now wanted to file a motion to modify custody or to somehow modify the controlling custody order, the court wouldn't have jurisdiction in Nevada to hear that.
Potentially. I don't know. I need to brief it because the issue is a party could just leave the state and divest the state of jurisdiction if we're talking about the termination case, which, and again, under the UCCJEA, the termination is a custody proceeding by definition under the
I understand. You're
UCCJEA. I
telling
understand
me
it's
you're
not
going back
to
over
modify.
information. You're going back over information I already know. You're not answering my question. My question is, I'm clarifying that the custody case, if he's left the state of Nevada, custody rests in Oregon. The jurisdiction to decide custody rests in Oregon. I would lose all jurisdiction if he's left the state of Nevada. And so essentially, the petition to terminate parental rights is kind of a dead end. It either gets granted or it doesn't, and then it ends Nevada's contact with this case, right?
Yeah, I'm not quite sure of your view on the termination. That's why I keep going to the same thing, because it's a dead end, but if you terminate his rights, it severs the ability. Okay, he's holding up an ID to the camera,
So,
but
but why are we going through this whole proceeding to terminate his parental rights when he's actively trying to establish a relationship with his children in Oregon? Doesn't that seem sort of pointless?
no, absolutely not.
Okay.
He's only trying to establish his custody because we filed the petition. He could have done many things prior to filing in the state of Oregon. He waited several months until the petition was on file in Nevada before he did anything in Oregon. And now it's been over a year
There
until he's
could be
actually
there could be 1,000 other reasons why he waited. It happened to be that it was after your client filed a petition to terminate parental rights. That doesn't necessarily mean that was the reason why he did it. There could be other reasons. But that's
a factual issue, an evidentiary issue.
It is a factual issue, but the challenge that the court's having is that you're asking, potentially these parties are living in other states, and you're asking a Nevada court to expend resources to decide a controversy that potentially it has no interest in or stake in. If in fact he's left the state of Nevada and the children have been living in Oregon for the last 3 years, and there's a case pending in Oregon. It just seems okay. Well, let's do this. If you think that there is a dispute about,
Well, Judge, can I, yeah.
Sure. Sorry.
Judge
Sorry,
Gordon,
Judge.
I guess when I'm looking at the statute, yeah, and help me, walk me through, because I'm interested in your point of view. I don't know what the statute is in Nevada. Ours is ORS 109.757, simultaneous proceeding. It says, a court of state, Oregon, may not exercise its jurisdiction if at the time of the commencement of the proceeding, a proceeding concerning the custody of the child has been commenced in the court of another state. So a proceeding concerning the custody, and you're saying that a termination of parental rights does not concern the custody of a child. I mean, to me, it seems like the ultimate decision of losing custody, but you're saying that you have a different point of view on that?
Yeah, I mean, I don't have the ability to modify custody as part of this petition.
Well, I'm just saying that it says, because you're saying that the termination of parental rights has no bearing on the motion to modify. But when I read the simultaneous, it says, if Oregon can't exercise its jurisdiction, if at the time of the commencement of the proceeding, which is, I'm assuming it's the motion to modify in Oregon, a proceeding concerning the custody of the child has been commenced in the court of another jurisdiction having jurisdiction, unless the proceeding has been terminated or stayed by the court of the other state. I mean, when I read that, it sounds like unless, the termination of parental rights, it's not a custody proceeding per se, but it does concern the custody of the child. But it sounds like you have a completely different point of view. But then if I go down to the jurisdiction to modify, if you didn't have that termination of parental rights, then we would just automatically go to jurisdiction to modify, which, and that's the step-by-step, could Oregon make an initial determination? Yes, it would be the children's home state. And the court of the other state determines that it no longer has exclusive continuing jurisdiction. I mean, help me understand
Well, that second question, did you just
I could
how you think the termination of parental rights action doesn't It sounds like it's not relevant or something to this conversation.
Well, so maybe I could clarify. I know that
Hold on, Ms. Fuji. Hold on.
our statute is NRS 125A.305, says custody proceedings include termination, parental rights, and the dependency court also falls under that. But in Nevada, when parties file to terminate parental rights, they file a different case number. They file it, so they are like separate yes or no answers. So maybe that will clarify. The simultaneous proceeding is NRS 125A.355. I was asking this court to stay the proceeding under forum nonconvenience, that Nevada should decline, because normally, since Nevada made the initial decree of divorce and custody order, Nevada would have exclusive continuing jurisdiction until it doesn't. And I believe it didn't when Candace moved. And now, especially if they are going forward with custody, anything and everything involving the children, meaning reunification therapy, say this court says we don't terminate, Nevada says we will not terminate, then where do you go from there? The case should proceed in Oregon, because that's where all the states, CPS, Oregon, law enforcement, Oregon, everything that mom's concerned about, and reunification therapy would be around the kids and where they reside. And nobody lives in Nevada. So Nevada, I agree with the court on that issue, that they would decline to exercise jurisdiction, and it should be Oregon.
Judge, can I also clarify as well? There was temporary orders from
No,
Nevada
hold
court
on.
that said that
I
was
don't
to
know
resolve
Mr.
criminal
McDonald.
matters and to
Mr.
get
McDonald.
an evaluation. Both of those requirements have been fulfilled.
Are you going to talk
she's
over me,
moved
sir?
out of the jurisdiction
Sir, this
of
is the
Nevada.
judge.
I don't know.
Sir, please stop talking. This is the judge. You're represented by counsel. All right?
My counsel in Oregon is not present, so that's why I'm speaking.
All right. Well,
We're just talking about procedural issues right now, Mr. McDonald, so please hold your thoughts. Judge Gordon.
Well, I mean, listen, you raise an interesting question, Judge. As Ms. Fuji pointed out, in Nevada, it's two separate cases, right? I mean, I have a custody action on one hand, and I've got a petition to terminate parental rights action. There's two separate cases. So in Nevada, they're certainly perceived as distinct, right?
Now, in Oregon, we would consolidate those cases. Is that not how you do it in Nevada, since it's the same children, the same family, the same parents?
Yeah, they're not consolidated. I mean, they're two separate cases. And different relief would be different relief.
They're separate. We file separately. So in a normal custody case, they'd have to retain counsel. In a termination case, they get court appointed if they qualify as indigent. The standard's higher, it's clear and convincing instead of preponderance by the evidence. It's just a heightened standard. So routinely they file separate. You file separate actions.
Well, yeah, they're filed. Yeah, we have separate case numbers, of course. I just meant they're consolidated, and typically the court would then decide which case proceeds first. But
yes,
I don't know. I just think it's interesting the fact that it's two different case numbers. But the bottom line is the mother and the children have been living in Oregon. So I think it ultimately a motion to modify. We haven't had the hearing, but I think a lot of these factors will be met. It's just that termination case that, to me, seems like that should be resolved, and that any motion to modify should be stayed. But there again, I'm happy to continue this, read the briefs, kind of understand a little bit deeper as to the arguments. What are your thoughts, Judge Gordon?
Well, I think we perhaps need to resolve the issue of residency one way or the other. I mean, I have previous briefs there from earlier this year regarding
Oh, can you hear me?
The parties' respective positions.
I can't hear the Nevada, but I can't hear Judge Gordon.
Oh,
okay.
Can you hear me?
Judge Gordon, are you, can you hear us?
Yeah, I can hear you. Can you hear me?
Let's see.
Sorry, it's not your fault.
Okay, how are we going to do this?
Are we muted?
Do you have his clerk or anything?
Can you hear me? Why don't we log? You want to log out, log back?
Okay, Judge Gordon, I think I can hear you now.
Oh, okay.
Okay, now I can hear you.
I mean, I already have the benefit of the parties' briefs regarding the form, the inconvenient form arguments.
Oh, I can't hear you anymore. Okay.
Can you hear me now?
Yes.
Okay. So let me ask you this. You have a motion pending there in Oregon to modify custody. Is that what it is?
He filed a motion to modify, but it's just at ground zero because we're going to have in this UCCJEA. So it's in the file. It hasn't gone anywhere because I didn't know if we were going to proceed in Oregon on a motion to modify. And so I thought we would have to have this conference, and when I just read the statute jurisdiction to modify, it says, let's see, a court of the state may not modify a child custody determination made by a court of another state unless a court of this state, Oregon, has jurisdiction to make an initial determination, which it would seem like it would since they've been living here 3 years, and then it's there's the court of the other state determines that it no longer has exclusive continuing jurisdiction, or that a court of this state, Oregon, would be a more convenient forum, or a court of this state determines that the child's parents, and any person acting as a parent do not presently reside in the other state.
And tell me again, that's the...
So I thought I needed to have that hearing before we moved forward on the motion to modify.
And give me again the statute there in Oregon that you're reading.
But then I thought we were at a standstill when I read that simultaneous proceeding, given the TPR in Nevada, where it said I cannot exercise jurisdiction unless Nevada stays its case or something. Anyway.
Yeah.
I would just note for the record that Mr. McDonald is improperly in the chat making his arguments. I don't know if that's part of it.
I asked my office to text him not to do that. Please, Michael, don't do that. Please.
Yeah, and I don't have access to chat, so I can't see it. Just to let you know.
Thank you.
Yeah.
Please don't, Michael. It's inappropriate.
Yeah, neither do I. Well, I think that I'm happy to look at additional briefing. I think that the residency issue probably needs to be addressed. We may need to do just a short evidentiary hearing on that. I'm not sure if we do that, we need to do that jointly, or if either jurisdiction can make that determination. I think under the statute, either jurisdiction can make that finding, but and potentially, I guess we could conduct it jointly. That's why I was trying to understand what
And Judge, if you feel like
evidence would be put on to address that.
I was just going to say, if you feel like we can proceed today at this time with a brief evidentiary hearing, we can certainly do that as well. I've got time.
I think I'll probably get objection from the parties. Mr. Fleeman probably wants time to prepare.
That's correct, Your Honor. I need to provide the exhibits that would be introduced at the evidentiary hearing, and probably have a third-party witness regarding the investigation that's occurred.
And Your Honor, I have what I produced in our 16.2 that's not a part to, that hasn't been provided to the court yet, is I have a copy of a lease and his driver's license, and then he responded to written discovery, 2 sets of written discovery. And I think he was deposed as well. So I have that I would offer in advance in evidence in support of his residency out of Nevada.
Can I propose something? I mean, I'm willing to offer any questions, and let's just proceed. It's been way too long. It's been over 2 years since I've been able to see the children, and the more the time that passes.
Okay, we understand.
So please, anything
We understand, Mr. McDonald, we understand.
procedural stuff. There's no jurisdiction in Nevada. There should be allowance.
Okay,
to
I
proceed
can't
in
mute
Oregon.
him, so
Thank
I
you.
would if I could.
please mute Mr. McDonald. So, Judge,
Well, this is, and
my
see, Mr.
understanding
Fleeman, this
is that
my-
I can't,
This is my concern, that if, that,
oh,
I'm sorry, Judge, go ahead.
go ahead, Judge. No.
No, I interrupted.
Oh, do you agree that I can't proceed until Nevada, is anybody on speaker? Because if you are, it usually echoes. How I read the statute is that I can't proceed until Nevada relinquishes jurisdiction. Go ahead, Judge.
Well, and see, that's where we kind of differed, and I didn't look at your statute, but I didn't read my statute that way, because I viewed what was pending here was just this termination of parental rights and not a custody proceeding per se. And if in fact the father had left the state of Nevada, then there would be no jurisdiction here in Nevada to commence a new custody proceeding. In other words, and a proceeding would be like a motion to modify. So if he has in fact left the state of Nevada, then the only thing that would sit in Nevada and remain potentially would be this petition to terminate parental rights, which isn't everything. That's why I'm not understanding why jurisdiction would stay in Nevada. I think that's why, it would make more sense to be there in Oregon. But I recognize that, yes, the petition to terminate parental rights is pending here in Nevada, and whether he's a resident of Nevada or Arizona, the court has that jurisdiction. But it just, I don't know why that's going to go forward when there's a motion to modify custody pending there in your jurisdiction, and he's trying to reestablish contact with his kids.
All right, it's my understanding that Mr. Fleeman, you'd like some time to brief. Are we going to look at another date to come back? Is that, I believe, where we are?
That's what I would request, Your Honor, yes.
Are the parties ready to proceed with the evidentiary? I mean, not today, but are you ready like in 2 weeks? I mean, we're supposed to expedite a resolution of this, correct?
Well, we are. It's supposed to be 6 months, I think, under SCR 251, if this is a custody proceeding. But in terms of an evidentiary...
I'm talking in terms of the UCCJEA has language that says that these matters are to be expedited and handled in, expeditiously. That's in the UCCJEA.
Well, I'm assuming my client would need to be present, and because it's an evidentiary hearing, which she would just need to make arrangements, so I think that would be the only issue about when the evidentiary hearing would be. She would need to just make arrangements to come here.
Do parties have a sense of how long the hearing would take?
For me, not long, I don't think. I would front load the exhibits I have in support and then make him available for questioning.
Yeah, I think a couple hours at the most. I don't see it being more than that.
So an afternoon?
Okay.
Yes, sure.
Okay.
I was hoping much shorter, like a half hour or hour.
And
I mean, it depends on how
a reason why we shouldn't do it via video conference?
I don't have any objection to it. I just didn't know if the court was okay with that.
I have no objection.
Judge Easterly, how do you feel about that?
Oh, that's fine.
What about
There's no way to proceed
I was
today.
looking.
what about either February 13th or February 14th in the afternoon? I have both of those afternoons available.
Are we on the same time zone?
We are Pacific time. I'm available on the 13th, but on the 14th, I am on a abuse neglect track, and that's every Wednesday. So I'm not available on the 14th, but I'm available on the 13th.
I'm available on the 13th as well.
Judge Easterly, does that work for your calendar?
Yes, and just for the record, Easter Day, just like the holiday.
I'm sorry.
So on the 13th, that's okay. What time are we thinking? I would be able to do it like starting like 2:30 would be the best. I could probably start at 2 o'clock and have the rest of the afternoon.
I think 2 o'clock works. Let's do 2 o'clock.
Okay. Okay. So we'll do WebEx just like we're doing now?
We'll do WebEx. The primary issue will be the Mr. McDonald's residence, correct? So.
Can I just answer the residential thing right now?
No,
I have
no.
all the evidence.
No.
It's ridiculous.
So I'm assuming the order of proof would be Ms. Fuji would begin, right? And then Mr. Fleeman would have a chance to respond. And then obviously you can present briefing as far as the issue of residency as well as the issue of form non-convenient. We'll address that at that time as well. I don't know what kind of evidence would need to be put on, or if that would just be argument you could make at the conclusion of the presentation of evidence.
That's fine, Your Honor.
Yeah, we would stipulate to argue on that issue.
I'm sorry, Mr. Fleeman, you'll just stipulate to just argument on that? Is that what you said?
On the form non-convenience, if we can brief it at the time, then yeah, just the argument.
Okay. All right. All right. I think that resolves it today. So we'll continue this to February 13th at 2 o'clock.
We have a deadline for the briefing, Your Honor.
Yeah. I was looking at maybe the 8th, February 8th. Judge Easterday, is that okay for you?
That sounds good.
And
Unless there's any other issues, we can sign off and we'll continue this to Tuesday, February 13th at 2 o'clock. And I'll reserve the rest of the afternoon for that.
Your Honor, do we want to get into the Oregon court as well? Just a copy of what we file in Nevada in some way so that Judge Easterday has it?
Yeah, I don't know how to.
Yeah, you can file it in the Oregon, let's see what case, I'm trying to find the case number, the Oregon horse number. You can also give me a courtesy copy. You can find my email address in the Oregon State Bar directory.
Thank you, Your Honor.
All right, thank you all.
Okay, all right. Well, we're going to hang up now unless there's anything further.
That concludes it. Thank you, Judge.